Reports have emerged that disgraced Paralympian Oscar Pistorius was eligible for parole 6 months ago. However, owing to a miscalculation of his prison term due to technicalities, he's still behind bars. Pistorius is doing time for fatally shooting his girlfriend Reva Steenkamp through a closed toilet door on Valentine's Day in 2013. For more on this, I'm now joined by legal expert advocate Khumisi Kganare. Khumisi, appreciate your time. Just give us some background on the Oscar Pistorius case, including conviction, subsequent appeals, and the ultimate charges he faced, which bring us to where we are at this juncture.
Yes, no, thanks a lot, Hugo. I mean, there's a very fat history to it. You'll remember that the initial charges that he faced were, if you may, culpable homicide, which is causing the death of another unintentionally. But we know that it was reviewed at SCA level, and it was considered to be a murder charge, if you may, that he had to deal with, and as a result, even his sentence had to be reviewed.
So what is the significance of the recent revelation that Oscar Pistorius became eligible for parole 6 months ago? How does this impact his legal situation?
Yeah, I mean, it's a technicality, like you said earlier on. And the law as we know it is, if you are serving, 24 months or less, you become eligible for parole as soon as, you have served about a quarter of your sentence. And if you are serving over 24 months, then you must have served half of your sentence to qualify to be considered for parole. And if we are talking life sentence, then it's something else. Then you must have served about 25 years of the sentence for you to be considered. And the conditions differ really in how that is dealt with.
So why did the authorities initially deny parole to Oscar Pistorius, claiming that he had not served half of his sentence, when in actual fact, from what we understand, he had?
Yeah, and it's a good thing that they admit that they made a mistake. And it's a question really of just placing the dates where they should and when the sentence, started and all those circumstances around his sentence. And if you get that right, then you are able to, do proper calculations that will lead you to the actual term. If we are looking at a sentence that's more than 24 months, in the case of Pistorius, that, come this time, we know for a fact he would have served half his sentence, and as a result, he's eligible. His application can come through. The board can consider it, which will come by way of a report from the case management committee. And if you get that wrong, obviously it's going to affect when his application for parole should be considered, and indirectly. That also affects his right not to be deprived, of his liberty without just cause.
So, are you suggesting that he immediately becomes eligible for parole as we speak? Are we expecting the wheels to start turning in that direction?
Yeah, sure. Even though he has lost a few months, if you may, but it should start running from now going forward, as opposed to the initial date which was set for August 2024. So we would expect that process to start running, a meeting to be set up where this hearing will be taking place. He will be given an opportunity to make his recommendations. But from the attitude that we see now, especially from the board and other committees, is they will not be opposing this process. So I expect him to get his parole without any problems.
Is this lack of opposition to the parole a result of the committee, if you will, or the legal department dropping the ball on the issue of his actual parole date?
I wouldn't want to say that, but it might be a consideration that, because we made a mistake here, maybe we should be lenient in how we handle the process. But the law will always dictate how these processes should be dealt with. I mean, we would expect still to get a report from the case management committee in respect of Pistorius. We would expect that a proper hearing be held. where there is a chairperson, a deputy chair, and people that form a part of that committee to consider this application properly and make a decision. And we know, it's a decision that can always be cancelled either by the minister or the national commissioner. But I don't see that happening. As soon as what needs to be done would have been done by the board itself.
Now, the parole application obviously has various possible outcomes. One of those outcomes might be that he might be denied parole. So what are the factors that go into this application? What are the conversations that are being had? What is that application from Pistorius' team suggesting? What are they saying in order for him to get that parole?
I mean, first and foremost, it would be that, look, now is the time that you are required, not necessarily, obligated by law, but this is the time that the law says we can entertain this sort of process. And number one, the time is right. Number two, Pistorius has served, half of his sentence, and we would say at this time he is ready, because remember, the purpose of the correctional system really is to put a sentenced offender in a position where they would be able to lead a responsibly social life in the future. And I think the future for Pistorius is now. So those would be the sort of arguments that are advanced by his legal team to say, look, he's been here and he's been doing these sort of courses while serving his sentence, and we believe he's ready. If there's anyone that you believe should be given an opportunity to come and also make representations, for instance, people that will be coming from River Steenkamp's family. But we know even with them, there are no issues of possible opposition. In fact, the legal representative says, the late father would have said, let the law take its course. And that would be what, this process will be about. So those are the sort of issues that would be advanced by Pistorius' legal representatives, and it is now for the board, to consider and make its decision. Also putting down conditions that would go with that, to say, we would expect you to report to a particular police station at this time, or whoever the correctional officer would be assigned to him, and there will be those sort of conditions, and he must accept those conditions for him to be released. If he doesn't accept them, then it becomes a problem. Then he cannot be released. But it doesn't happen often where you get offenders opposing conditions that are put down by the board.
Advocate Khumisi, the right to parole, in fact, is a basic human right. A basic legal right, if I am correct. Is that position accurate?
You look, it all goes back to our constitution, and you're not gonna find it there verbatim, that offenders, have the right to parole, but it's dealt with under Section 12 of our Constitution, which says everyone has the right not to be deprived of their freedom without just cause, and this would fall, and also that freedom is not taken away from them arbitrarily. Which is what we would say happened in this case by not considering issues properly insofar as they relate to dates and so on. So accused persons, they do have that right to parole encompassed in that way in the Constitution under Section 12.
So if Oscar Pistorius is then granted parole in the next few weeks, right, is a state liable for denying him those 6 months, if it is 6 months, that have lapsed since he was actually should have been given parole? Are they liable?
Remember, when we talk parole, it's not as if the board is obliged to give an offender parole. What this does is that it makes them eligible, to be considered for parole. But the decision can be that he gets it or he doesn't get it. And the only time when the board is obliged to consider a parole, not to grant parole, but to consider it, is when an offender has served 25 years of their sentence. That's, in life sentence situations. So it's unlike a situation where you would want to sue for wrongful arrest. Here we are talking something that is, if you may, somewhat of a discretion on the part of the board to eventually decide whether or not you are you should be granted parole. So at the time when he was due to be considered for parole, we do not know whether or not he was going to be granted that parole. There's a process that needs to unfold. There is a report that needs to be put together by the case management committee, and there's a lot that goes into that report. That report has to be presented to the board. The board has to consider it where it needs clarifications, but it happens almost all the time that they invite the sentenced offender to come and make representations. After that, then they can make a decision whether or not parole is granted, and if it's granted, they would, obviously have conditions how that will be dealt with. If it's denied, they must give reasons, so as to enable the sentenced offender to decide whether or not they would want to challenge that decision. And you need the reasons for you to be able to challenge by way of a review application, if you may.
Now, given the legal complexities and discrepancies highlighted in this case, what lessons can be drawn regarding the administration of justice and correctional services in South Africa?
I would say, mistakes happen. It's highly likely not the first time something like this happens. And, we can take comfort in the fact that, at any time you have the right to challenge whatever that you believe, be it you are sentenced, you are accused, that whatever happened infringes your rights, and you can challenge that any time. I think that's something we can take comfort knowing that there's always an opportunity for you to launch a legal process challenging decisions or challenging processes, because at the end of the day, whatever is done by an organ of state or anyone who exercises public power, they must tick all the right boxes procedurally and substantively.
Advocate Khumisi Kganare, I appreciate your time speaking to us around the Oscar Pistorius eligibility for parole, owing to a miscalculation of his prison term due to some technicalities. More in the news.